Thank you for visiting the Waterkotte website and our Federal Wire Fraud Defense Lawyers in Missouri website page. Regardless of the crime, we believe everyone is entitled to the best possible legal defense in the state of Missouri. We have created this audio version of our website page to help you better understand our services and protect your future, freedom, and reputation. If you have been charged with federal wire fraud in the state of Missouri, we can help. Don't face the state and court system alone during your federal wire fraud charge. Contact one of our federal wire fraud defense lawyers today at 314-900-HELP to protect your rights and future. Waterkotte is committed to handling all federal wire fraud defense cases with confidential care and understanding. We are not here to judge you. We believe that everyone in Missouri, regardless of the crime they have been charged with, deserves an aggressive legal defense and to have their legal rights protected. With that being said, let's discuss hiring our federal wire fraud lawyers in Missouri and setting up a free consultation with our attorneys. Federal wire fraud lawyer in Missouri. Federal wire fraud is one of the most serious white-collar crimes prosecuted in Missouri's U.S. district courts. Even an unsuccessful attempt to deceive someone through electronic communication, like emails, texts, or online transactions, can trigger felony charges. If you're being investigated or have been charged with wire fraud, you need a lawyer who understands the stakes and how federal prosecutors build their cases. Waterkotte defends individuals and businesses across Missouri facing complex federal fraud allegations with offices in St. Louis and Kansas City. Why you need a Missouri federal wire fraud defense attorney. Being accused of wire fraud means you're facing the full force of the federal government. These cases are investigated by agencies like the FBI, IRS, or Department of Justice, and prosecuted by U.S. attorneys who specialize in white-collar offenses. Once charges are filed, your future is at risk, even if no money changed hands. Unlike state-level cases, federal prosecutions are often backed by months of surveillance, subpoenaed financial records, and digital evidence pulled from emails, texts, or business systems. These cases are built for conviction, not plea bargains. That's why it's critical to have a Missouri wire fraud defense lawyer who knows how to challenge the government's narrative from day one. Waterkotte's Missouri federal wire fraud attorneys, we understand the pressure and uncertainty that come with being under federal investigation. We act quickly to protect your rights, assess the evidence, and position your case for the strongest possible defense, whether that means fighting the charges in court or resolving the matter discreetly before it escalates. What is federal wire fraud? What is federal wire fraud? Federal wire fraud is a crime under 18 U.S.C. Section 1343 that involves using electronic communication, such as phone calls, emails, text messages, or internet transactions, to deceive someone in order to obtain money, property, or services. It does not require that the fraud was successful. An attempt alone can result in felony charges. To be charged with wire fraud, prosecutors must allege that you engaged in a scheme to defraud and used interstate wire communications to carry it out. The communication doesn't have to be elaborate. Even a single misleading email, text, or online form submission can trigger a federal case. Examples of federal wire fraud: sending fraudulent emails to investors promising fake returns, making deceptive online transactions through e-commerce platforms, using text messages to misrepresent services in a business scheme, transmitting false financial data to lenders or banks via internet. What makes wire fraud so dangerous is how broadly it can be applied. Prosecutors don't have to prove that you benefited. only that you intended to deceive and used electronic communication to further the plan. That's why it's essential to speak to a lawyer before talking to investigators or responding to subpoenas. Federal elements of wire fraud. In order to convict someone of wire fraud under federal law, prosecutors must prove several specific elements beyond a reasonable doubt. These elements are laid out in 18 U.S.C. Section 1343 and are consistent across all federal jurisdictions, including the Eastern and Western Districts of Missouri. Key elements of a federal wire fraud charge. Scheme to defraud. There must be a deliberate plan or effort to deceive someone in order to obtain money, property, or services. Intent to defraud. The defendant must have knowingly and willfully intended to deceive or cheat the alleged victim. Use of interstate wire communications. The fraudulent scheme must involve electronic communications like phone calls, emails, texts, or internet use that cross state lines or affect interstate commerce. Material misrepresentation. The false statements or omissions must be significant enough to influence the alleged victim's decisions or actions. Each of these elements must be met for the government to secure a conviction. If even one is weak or unproven, the entire case may fall apart. A skilled federal defense attorney will focus on breaking down these elements, especially intent and materiality, to undermine the prosecution's case. What evidence is needed to prove wire fraud? In federal wire fraud cases, prosecutors rely on a wide range of digital and financial evidence to prove their case. Because wire fraud involves the use of electronic communication, the government often builds its argument around a paper trail of messages, transactions, and internal documents, all designed to show intent and deception. Common evidence in wire fraud prosecutions. Emails, text messages, or voicemails containing false or misleading claims. Bank and credit card statements showing financial transfers tied to the scheme. Contracts, invoices, or business communications suggesting deceptive practices. Internal company records or spreadsheets tracking fraudulent activity. Testimony from alleged victims or cooperating witnesses. Expert analysis of financial transactions or digital communications. The government doesn't need a confession or direct evidence of fraud to bring charges. Often, prosecutors try to build a circumstantial case based on patterns and timing. That's why your defense team must be prepared to question the context, accuracy, and meaning of every document, and challenge assumptions that link you to the alleged scheme. What is conspiracy wire fraud? Federal conspiracy wire fraud charges are brought under 18 U.S.C. Section 371, which makes it a crime to agree with one or more people to commit wire fraud, even if the fraud was never completed. In other words, you can face felony charges simply for participating in a plan or taking a step toward carrying it out. Prosecutors often use conspiracy charges to broaden the scope of their case and sweep in additional defendants. If you're accused of being part of a larger scheme, especially in business, investment, or tech-related contexts, the government may argue that you knowingly advanced or supported the fraud, even if you didn't personally send any deceptive messages. Conspiracy wire fraud can be charged when you allegedly discussed or planned a scheme involving electronic communications. You forwarded information or facilitated transactions tied to the fraud. You worked alongside others accused of wire fraud, even with limited involvement. You took actions that prosecutors view as furthering the goal of deception. Conspiracy charges often rely on circumstantial evidence and guilt by association. A strong defense focuses on your specific actions and intent, not just who you know or where you worked. Our Missouri federal crime defense attorneys push back hard against overreach and fight to keep our clients from being caught in a wide prosecutorial net. Sentencing for federal wire fraud in Missouri. Federal wire fraud is a felony offense that carries severe penalties, including lengthy prison sentences, steep fines, and asset forfeiture. Sentencing in these cases is determined by federal guidelines, which take into account the amount of money involved, the number of alleged victims, and whether the fraud targeted vulnerable individuals or institutions. Potential penalties under 18 U.S.C. Section 1343. Prison time. Up to 20 years in federal prison, and up to 30 years if the fraud involved a financial institution or federal disaster relief funds. Fines. Up to $250,000 for individuals, or twice the amount of loss or gain, whichever is greater. Restitution. Mandatory repayment to alleged victims of any actual financial losses. Asset forfeiture. The government can seize money, property, or assets allegedly connected to the offense. Federal sentencing enhancements. The actual sentence imposed can be far more severe if aggravating factors apply. Enhancements may include high dollar amounts, especially over $250,000, 10 or more victims, use of sophisticated means or offshore accounts, abuse of a position of trust, e.g., financial advisor, executive, obstruction of justice or destruction of evidence. These enhancements can add years to a sentence, even for first-time offenders. That's why it's critical to work with a Missouri federal wire fraud defense attorney who understands how to challenge enhancements and present mitigating evidence during the sentencing phase. Experienced Missouri wire fraud defense for complex federal fraud investigations. Wire fraud cases involve detailed digital evidence and complex investigations across state lines. Combs, Waterkotte knows how to break down these cases and find weaknesses in the government's claims. What makes wire fraud cases so complex? Electronic evidence like emails and texts. Multi-agency investigations, FBI, DOJ, IRS. Financial record analysis by experts. Conspiracy overlap and multiple defendants. How we defend you. Challenge intent and digital interpretations. Expose timeline gaps and missing evidence. Dispute expert financial conclusions. Separate you from broader fraud claims. Why choose Combs, Waterkotte for wire fraud defense? When you're charged with wire fraud, you need a defense team that knows how to counter complex federal cases. With over 50 years of combined experience, Combs Waterkotte delivers sharp strategy, clear guidance, and aggressive courtroom advocacy. From day one, we focus on protecting your rights, minimizing your exposure, and pushing back against flawed government evidence. With offices in St. Louis and Kansas City, we defend clients across Missouri facing serious white-collar charges. Contact a Missouri federal wire fraud lawyer today. Wire fraud charges move fast, and so should your defense. The federal government is already working against you. Don't wait to protect your future. We're ready to challenge the case, protect your rights, and fight for your freedom. Contact us online or call 314-900-HELP today for a confidential consultation.